with college students, it presents problems for the parents, particularly at the felony level, because when kids are in college and they get charged with felonies, especially if they're receiving any type of financial aid, any type of felony conviction can completely obliterate their ability to continue to obtain financial aid. And of course, any blemish on their record is going to impact on their ability to obtain a job, a decent job. So we are constantly presented with challenges related to college students.
When we began the courtroomsharks.com website, this was one of our major concerns, is that people of college age, about to enter college or in college, are often the subject of car stops, which either yield DWIs or yield possession of drugs in the vehicle, or perhaps worse things. And we have discussed frequently that, you know, the permanent damage that could cause to that person's getting further in life. In today's economy, a person simply can't afford to have a criminal record. There's less jobs available today. If there's 100 applicants for one job and you're the guy with the criminal record, you're definitely not getting called for.
Well, Michael, you mentioned car searches. In an effort here, I don't want you to be modest. I want you to talk about the Supreme Court ruling a few years ago relative to car searches that you spearheaded.
What the Supreme Court did was they wanted to address the issue from a completely clean slate, meaning should they adopt a federal standard of searching cars, or should we develop our own very unique, very clear set of principles in New Jersey for searching cars? And I am delighted, proud to admit that I argued that case before the Supreme Court together with many other lawyers, but it was my case that brought us to that place. And in that decision, we created a much more favorable atmosphere and much greater protection for the drivers and occupants of cars as the Supreme Court set out a new course of rules and conduct and protocols as a result of the case that I was involved in.
Now, one of the other, on a much smaller scale, or I should say much less serious scale, because it's not a felony, but one of the big things that we deal with college-age students is DWIs. Now, again, let me be clear. A DWI is not a felony. It's a traffic offense, and it's handled in the municipal court. But as a traffic offense, it is the most serious traffic offense that you can be charged with, because at a first offense level, it carries a driver's license suspension up to a year. At a second offense level, it carries a driver's license suspension for 2 years. And at a third offense, it's a 10-year loss of driving privileges and up to 6 months in prison. Now, people often ask me, if they're confronted with a DWI situation, is it better to take the breath test or not take the breath test? Fortunately, there's a very simple answer. Always take the breath test. Because what people don't realize is if you don't take the breath test, you're going to get charged with a refusal to take a breath test. And what people are not aware of is refusal to take a breath test carries the exact same penalties as a DWI. And if you refuse to take the breath test, you've completely eliminated any chance for your attorney to argue certain defenses that would exist if you take a breath test. A breath test instrument, like a radar instrument in a speeding case, for example, is a scientific instrument. And as a scientific instrument, there's certain forensic defenses that we can present to challenge the reading, exclude the reading from evidence. If you refuse to take the breath test, sadly, there's no defense to that. And it's as though you were convicted of a DWI. So the long and the short of it is always take a breath test, because you give your attorney the ability to challenge it, make certain arguments on your behalf, and possibly suppress it from evidence.
And along the same lines, probably the second most frequently question we get is that if I'm stopped by the police, and if when I roll down my window, they tell me they smell marijuana, whether it's burnt marijuana or raw marijuana, should I consent to them searching my car? And that answer, again, is no. Do not consent to search the car. Let them bring out the dogs. Let them impound the vehicle. Because the chances are, if you do not give them consent to search the car, They will search the car, and in doing so, we will probably find a way to have that search declared by the judge to have committed illegally and in violation of your constitutional rights. Once you grant that consent to search the car, you've given up all of those rights, and you've given up all of those defenses.